make sure that your family counsel, your family law team is are retirement benefits, whether that be, and other things like inheritances. So there needs to be some understanding of, future planning, not only the division of those assets, what is and what is not separate property. Things that are typically inherited are generally considered separate property, which means they don't they don't fall within the division of the marital estate. And then in addition to that, there needs to be some ability to analyze and deal with pre and post-nup agreements. A prenuptial or a post-nuptial agreement, which is in plain English means an agreement between spouses prior to marriage where parties are going to treat property differently than community property, or there's going to be a contractual agreement to treat property not as community assets and thereby protect. This usually comes about when you've got people who are older who marry and they have substantial estates, separate property estates, and they just don't want there to be an issue, usually with relatives, about some claim on the division of that estate, which may become community over the years, or maybe there'll be some blending of community assets. So they want that set out in stone in a contract that's not going to be treated that way. And then, of course, spouses in Texas have the right through contract to change the character. Spouses in Texas have the right to contractually change the character of an asset. In other words, they can change a community asset into a separate property asset and vice versa. In addition, your family law team needs to be able to help you deal with the accumulation of assets over generations, and that comes up in situations where there have been trusts and other large assets, family partnerships, large tracts of land, farm, rental properties that may have been pooled together and left behind to family members, and how that is going to be characterized in the dissolution of any marriage.